Hi, I'm James Anderson. I'm an estate planning attorney here in Fountain Inn, South Carolina. I've practiced in this field for over 18 years, and we've done somewhere north of 7,500 estate plans and counting at this point. I built Plan to solve a specific problem, and I want to walk you through my reasoning. Now, this service is not for everyone. If you have a complex business interest, blended family with competing inheritance concerns, a beneficiary with a disability who needs special needs trust planning, or you simply want face-to-face interaction with your attorney, you should have that, and our firm does that work every day. Plan is not a replacement for that. Plan is for people whose situations are straightforward, but whose schedules are not. Young families, dual income households, teachers, nurses, first responders, people whose Monday through Friday doesn't have a 2-hour gap for a law office visit. You know you need this done, you just need a way to do it that respects your time. So let me explain what you're actually getting and why it's structured this way. Every planned plan is built around a revocable living trust, not a will. That's a deliberate choice. And here's why it matters. A will is a set of instructions directed at a probate court. It has no legal effect until you die, and then it has to be filed, validated, and administered through a court-supervised process. In South Carolina, that process realistically takes 1 to 18 months to 3 years or more, anywhere in between. I'm not being dramatic. Our probate courts are overwhelmed, and the statutory timeline that gets quoted online does not reflect what actually happens on the ground. A revocable trust operates during your lifetime. You transfer your assets into it. You control everything exactly as you do now. And when something happens to you, your successor trustee steps in and manages the transition without court involvement, no filings, no waiting, no attorney's fees for probate administration. But here's the critical piece most people miss, and that every national online service glosses over. The trust only works for assets that are actually in the trust. If you sign a trust document but your house is still titled in your personal name, that house goes through probate. And the trust doesn't help us there. So that process of transferring or retitling your real property into your trust by recording a new deed, well, that's called trust funding. It's the step that makes the whole thing work. It's where the rubber meets the road. It's the step that national services don't do. They can't, practically speaking. They don't have South Carolina attorneys reviewing your current deed, preparing a new one that meets our state's requirements, and recording it in the correct county. We do. It's all included in our flat fee. Every planned plan includes deed preparation for your primary residence. Your plan also includes a pour-over will as a safety net, a durable power of attorney, a healthcare power of attorney compliant with the South Carolina statutory form, and a standalone HIPAA authorization. Those are all South Carolina specific documents drafted by an attorney who practices here, not generated from a national template library. The fee is flat, $9.95 for an individual, $1,495 for a married couple. No hourly billing, no add-on charges, no consultation fee that turns into a sales pitch. That's the number. If you're the kind of person who wants to understand exactly what you're buying and why, and you've read this far, so you probably are, hang out here at Plan.co. Everything's all laid out for you, and you can get started when it works for your schedule, not ours. Thank you and have a great day.